What are criminal assets and how can they be recovered? Criminal assets are obtained or held illegally, resulted from crimes, intended for commission of crimes, used to reward a criminal, object of money laundering or terrorist financing, or goods to which damage can be recovered. The criminal asset recovery process is complex and includes several steps. It all starts with the exchange of information between public institutions, individuals or legal entities, and even international institutions and foreign counterparts. The criminal investigation process can be initiated by the prosecutor's office, the National Anti-Corruption Center, the General Police Inspectorate, the Customs Service, or the State Fiscal Service. The criminal investigation officer issues an order to commence a criminal investigation and sends it to the prosecutor. He later approves or rejects the order received or can issue an order independently. If the order is approved, then institutions start to collect evidence and pursue the offender. Based on the evidence, the criminal investigation officer or the prosecutor decides whether there is enough evidence to recognize the person as a suspect or accused. The financial investigations begin. Several institutions can carry out financial investigations. The prosecutor's office, the National Anti-Corruption Center, the General Police Inspectorate, the Customs Service and the State Fiscal Service have the obligation and competence to act independently to conduct parallel financial investigations. The Criminal Assets Recovery Agency, CARA, can carry out investigations only at the request of the Prosecutor's Office, the National Anti-Corruption Center, the General Police Inspectorate, the Customs Service, and the State Fiscal Service. CARA cannot work independently of other institutions and doesn't have the right to initiate parallel financial investigations without an official delegation. Upon request, the Security and Intelligence Service and the Office for the Prevention and Fight Against Money Laundering may provide information. CARA can conduct parallel financial investigations in the framework of criminal prosecution on 55 types of crimes, including corruption-related crimes, organized crime, money laundering, drug trafficking, human trafficking, smuggling, tax evasion. That is, crimes that are within the competence of not only the National Anti-Corruption Center and the Prosecutor's Office, but also the competence of the General Police Inspectorate, the Customs Service, and the State Tax Service. If criminal assets have been detected as a result of investigations, then the assets are frozen or seized. That is, the owner is prohibited to use them until the final decision of the court. CARA is the only institution that, in addition to seizure, has the competence to freeze assets. Under the order issued by the competent institution, the prosecutor's office applies for seizure in court. The court, in turn, authorizes or rejects the seizure requested by the prosecutor's office. Once preserved, the assets are administered by specialized institutions. CARA keeps records of seized assets for the 55 crimes within its competence. It is also responsible for the evaluation, administration, and anticipated sale of seized assets before their confiscation. The Ministry of Finance manages seized assets for other types of crimes, and the State Fiscal Service is responsible for perishable assets. If the case contains conclusive evidence at the request of the prosecutor, the assets are confiscated by a court judgment. The confiscation order is followed by the actual recovery of assets by the State Fiscal Service and bailiffs. The state may collect and use confiscated assets or their value. certain goods may be subject to social reuse. Competent institutions communicate to the public the results of the process of assets recovery through press releases, reports, statistics, and more. The process of recovering criminal assets is lengthy and may take several years.